Alright, I'm going to be talking about some things that I have learned and what we're doing in my legal and ethical issues class at Jacksonville State. These are all basic things that I hope most of you know, but sometimes it's good to be reminded and keep these things in mind. Obviously, as early as 1962, school-sponsored prayer was declared to be illegal. And in 1985, they declared it illegal to even set aside a period of silence. And that all has to do with the First Amendment right to separation of church and state. Even for meditation or voluntary prayer, we can't even do that. And as employees of the state, educators must not endorse any kind of prayer or meditation. We have to remain neutral on pretty much anything concerning religion. Can't encourage in one way, can't discourage any type of religion either. 92, in this case, said that clergy, pastors, people like that cannot deliver prayers or sermons at graduation ceremonies. This was a big case in 92 to where they did say that when prayer is completely student initiated and student led, it is legal. But they cannot have any encouragement or anything from school personnel. Bible reading is permissible only when it's used as a literary or historical document. And we cannot require students to say the Pledge of Allegiance. You cannot require them to do that anyway. You can't punish them for doing it. You can't take off any daily grades or anything like that for not standing up and saying the Pledge of Allegiance. Any comments so far?
Can we not make them stand up, but not insist that they say something? I was thinking that they did at least have to stand up.
I've always made mine stand.
Is that
So you don't have to say anything, but you're gonna stand up.
And I think, because we have a responsibility to teach them citizenship, and I would have thought that would have been part of it. I mean, I agree with you that they should be required to show some appreciation for it, but based on what I've read, you cannot require them to recite it. Now, standing, I don't know. I'll have to read further into that.
And it depends on the circumstances, like, say for instance, if it's at a ceremony or at a football game or something, possibly standing would be just enough to do it. So, you really wouldn't, but like if it's in class, I mean, it'll be up to the child's decision, a conscious decision.
And this goes along with religion because they put under God in there. That's why I put it in here under religion. And that also has to do with freedom of expression, which I'll talk about now. So just refrain from endorsing any religious activities or displays. Do not prohibit a student from participating in any religious activity, as long as it does not disturb the school or go against any school rules, and do not encourage students to participate in religious activities. Freedom of expression, students have the same constitutional rights that we do, even when they are in school. They cannot be disciplined for wearing symbols bearing expressions of opinion unless it causes disruption. This came in 69. Some students were protesting the war in Vietnam. They were wearing black wristbands, and it caused no disruption. But because their expression of opinion was not of the popular opinion, they were suspended, and they ended up winning that lawsuit. They have the right to participate in protests and demonstrations if they are peaceful and do not violate school rules. And they may be disallowed if they obstruct school processes. I know we don't have a school newspaper, but just in case anybody ever does get involved in one of those, school officials, school personnel does or do have editorial control over it. The courts generally say that you shouldn't have broad censorship over it. The student should be able to come up with what goes in the school newspaper, and it's your responsibility as the educator to ensure that nothing inappropriate goes in there. But you should not have broad censorship of it, telling them exactly what needs to be in there. Search and seizure. Students have protection from unreasonable search and seizure. You can, well, school official, an administrator, in our case, search may be initiated when the school official has reasonable individualized suspicion based on information from a reliable known person. Reasonable, that's a judgment call. Did you get your information from a reliable person, or did it come from somewhere else? Individualized means it has to be one particular person. You cannot search all students in a class. That is illegal. Personal searches of a student, like on their body, should be avoided unless overwhelming evidence of a safety threat exists. They got a bomb on their person or anything like that. Due process, students should be afforded due process. They can't be punished and not know what they're being punished for. They must be informed of the rule violation and be given an opportunity to respond to that violation. They should be allowed to present their side of the story, and parents should be provided with a written explanation of the rule violation and punishment received, which our referral process does a good job of that, and they receive that copy of exactly what they did and the discipline involved. Alright, student records, confidentiality issues, Family Educational Rights and Privacy Act protects that. Records are kept in our record room, and I think we're good on that. They should be accurate and contain only necessary materials. They shouldn't contain anything like, he got in a fight this time. Usually disciplinary procedures are not included in these records. And they should remain confidential unless a guardian signs consent of release. Parents, students, and school personnel may review these records. Educational personnel, in our case, only if there's an educational need to view the record. And I know when I go to IUPs and stuff like that, when you're viewing the record, you'll sign it and say that you've done it, and that's protocol for this act. Alright, liability. Gossip among teachers that is intended to harm a student's reputation may result in charges of slander. You must have a legitimate purpose for disclosing any information about a student to another authorized person, authorized people being other teachers at school. It's okay to say, watch out for this, she's having problems with this. That serves a real purpose. But don't go around gossiping for unreasonable purposes, or never take information about a student outside the school to unauthorized persons. Alright, individuals with disabilities, obviously No Child Left Behind says that children with disabilities should be educated with the regular student population to the largest extent possible. And regular classroom teachers have the responsibility to identify students in need of special services, and we do this through RTI. And students can be punished for behavior not associated with their disability. They can never be punished, obviously, for behavior that is due to their disability. Suspensions longer than 10 days require a meeting of the placement team. Am I right on this?
IEP team.
Yeah, and that's why we watch the suspensions for these students with IEPs, because anything longer than 10 days is considered a long-term placement, and the IEP team must meet to determine if that's in the best interest of the child. Alright, and finally I want to end with the Alabama Educator Code of Ethics. Who is familiar with this? Ever heard of this document? Do what now?
Mr. Boswell never.
Did he? I hadn't heard. I think it, this version of it, I don't know if there's one before it, this didn't come into play until 2009. First of all, professional conduct. All teachers should be recognized as professionals and act accordingly. Unethical behavior would be harassment, inappropriate language, physical altercations, and failure to supervise your students. And as we're going through this, any violation of these codes of conduct can result in taking your certificate away from you. Trustworthiness must exemplify honesty and integrity in the course of professional practice. So don't falsify any information, student test results, things like that. All laws. Number 4, student-teacher relationship. Maintain professional relationship with students at all times, inside and outside the classroom. Refrain from the use of alcohol and or tobacco during the course of professional practice, and never use illegal or or unauthorized drugs. And educate or entrust with public funds and property should honor that trust with a high level of honesty, accuracy, and responsibility. So be sure you know what's supposed to be done as far as turning in money. All right, remunerative conduct, this has to do with, accepting gifts. I think, correct me if I'm wrong, are we allowed to accept any gifts from students?
There's something with a voucher.
$25 is what I last read. $50 in a calendar year,
Did it change?
something like that. Anyway, this has to do with this, and, basically, don't use your institutional privileges for personal gain. School policies and procedures should not be impacted by the gift of gratuity, so you can accept gifts, I think, up to $25, but, it shouldn't be used as a bribe or anything like that. I covered confidentiality already, and abandonment of contract, be sure that you fulfill all the terms, and do not refuse to perform services required by your contract. Any questions or comments? Great. Moving on,